Good afternoon, everyone. I'd like to take this opportunity to welcome everyone to the House Economic Matters Committee. Today is Tuesday, March 30th, 2021. We are on voting list number 19, and we will start with House Bill 43.
House Bill 43 is on the same subject as House Bill 97, which just passed third reading today. This conflicts with House Bill 97.
Move unfavorable. And I did speak to the delegate. She understands we are doing this today.
Okay. So there has been a motion for an unfavorable and a second on House Bill 43. Madam Vice Chair.
Yes.
Delegate Brooks.
Yes.
Delegate Fisher is excused. Delegate Queen. Delegate Queen is excused. Delegate Turner. Delegate Turner. All right. Excuse Delegate Rogers.
Do we have a quorum?
Where the hell is everybody?
I think Delegate Walker's finished eating. He's logging on now.
Yeah, it was good.
There was an email about 3 o'clock. But...
Yeah, it wasn't even about 3, but it was good, Kris.
We do have a quorum.
Yes.
Thanks to the.
Let me go back to where we were now. Delegate Rogers? Delegate Carey?
Yes on the unfavorable.
Delegate Jackson?
You're muted.
Yes.
Delegate Pippy?
Yes to the unfavorable.
Delegate Mouts?
Yes.
Delegate Wilson?
Yep.
Delegate Impalaria?
Yes.
Delegate Branch?
Yep.
Delegate Valderrama?
Aye.
Delegate Walker?
Yes.
Delegate Chi?
Yes.
Delegate Adams?
Yes.
Delegate Arentz?
Yes.
Delegate Fennell?
Yes.
Delegate Charkoudian?
Yes.
Delegate Howard? Delegate Howard's excused. Delegate Crosby?
Mr. Chair, I just got in. What bill are we on?
43 unfavorable.
The first one unfavorable, not necessary.
Aye.
And Delegate Watson. All right, Delegate Watson's excused. Tell you what, guys, let's give us about 2 minutes before we get to the next bill. We're staff is calling some of the members, so we'll give
I'm sending him a text too.
Okay.
Delegate Turner is on.
Okay.
Okay, yes.
You don't know what you're voting on.
Which bill is it?
Shocking.
It was just an unfavorable for conflict. You didn't miss anything.
Oh, I didn't miss anything. Whatever it is, I'm yes. Okay.
You just voted for toll roads on the Woodrow Wilson Bridge.
Oh no.
He's messing with you. Let's keep it together, guys. Hold on. Let me see if I can find another one. Tell you what, let's go to Senate Bill. Let's go to Senate Bill 651. That's the permanent partial workers of Baltimore County.
Senate Bill 651 is identical to House Bill 85 as passed by the House.
Move favorable.
Second.
Moved and seconded for favorable. Madam Vice Chair.
Yes.
Delegate Brooks.
Yes.
Delegate Fisher. is excused. Delegate Queen. Delegate Turner.
Yes.
Delegate Rogers.
Yes.
Delegate Carey.
Yes.
Delegate Jackson. Delegate Jackson.
You're muted.
Yes.
Delegate Pippy.
Yes.
Delegate Mouts.
Yes.
Delegate Wilson.
Yep.
Delegate Impalaria.
Yes.
Delegate Branch.
Yep.
Delegate Valderrama.
Aye.
Delegate Walker.
Yes.
Delegate Chi.
Yes.
Delegate Adams.
Yes.
Delegate Arentz.
Yes.
Delegate Fennell.
Yes.
Delegate Charkoudian.
Yes.
Delegate Howard. Still excused. Delegate Crosby.
Yes.
And Delegate Watson. Excused. Let's try Senate Bill 793.
Okay. Senate Bill 793, as amended, is identical to House Bill 1242, as passed by the House. Senate Bill establishes a beer and wine consumption permit and a beer and wine and liquor consumption permit in Frederick County. The amendments alter the annual fee for the consumption permit and alters the total quantity of liquor that an individual may consume under a certain circumstance.
So
and
Tiffany,
conforms the bill.
this is not, so this is amended.
This is amended.
Okay. Is there a motion on the amendment?
Move the amendments.
Second.
All in favor signify by aye.
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 Opposed, nay.
Move the bill as amended.
Second.
Moved and seconded for favorable as amended on Senate Bill 793. Madam Vice Chair.
Yes.
Delegate Brooks.
Aye.
Delegate Fisher.
Aye.
Delegate Queen.
Yes.
Delegate Turner.
Yes.
Delegate Rogers.
Yes.
Delegate Carey.
Yes.
Delegate Jackson.
Yes.
Delegate Pippy.
Yes.
Delegate Mouts.
Yes.
Delegate Wilson.
Yes.
Delegate Impalaria.
Yes.
Delegate Branch.
Yep.
Delegate Valderrama.
Aye.
Delegate Walker.
Yes.
Delegate Chi.
Yes.
Delegate Adams.
Yes.
Delegate Arentz.
Yes.
Delegate Fennell.
Yes.
Delegate Charkoudian.
Yes.
Delegate Howard.
Yes.
Delegate Crosby.
Yes.
And Delegate Watson.
Yes.
Got it. All right, so we got it. All right. I'm gonna sort of go back in order now, but starting at 1262, and we'll work our way down from there. House Bill 1262.
House Bill 1262 is the bill that changes the way that electricians are regulated in the state. The bill was held last voting session for some amendments from Delegate Mounts, but I don't believe the committee's received any additional amendments.
Yeah, we've been in touch with the amendments office today. They're still working on them. So I don't know what the delay is, but I'm sure there's a valid reason. They're drafting them.
Okay. No, fair enough. That's not your fault. We will check in with them, but for now we'll hold it. And I guess that applies to 762 as well, I would imagine. All right. Were you going to say something, Delegate Adams?
No.
No.
Senate Bill,
I thought we were on
Senate
581.
Bill-
I'm good now.
Senate Bill 93.
Chairman Davis,
Yes.
some of us were under the impression we were going at 3. So can you just catch us up to where we are? Please.
We
Tell us where
voted
we are.
on House, we voted, I think, 3 bills before you got here. House
Okay.
43 was withdrawn. Well, not a withdrawn, it was
Unfavorable.
It was unfavorable, conflicted with another bill we had done earlier, I believe Delegate Lehrman's bill.
Correct.
Then there was one alcohol bill, Senate Bill 793, the Frederick County alcohol bill, and then Senate Bill 651, Senator Klausmeyer's bill that dealt with the permanent partial disability. I believe there was a House crossfire to that, if I'm remembering correctly. So those
Okay.
were the only 3.
So you voted on this. Okay, thank you so much.
Yes, ma'am. Senate Bill 90. Hold on, what did we do with 1262? We held
It's on
it.
hold.
Held it.
We're holding both those in the Senate bill, Mr. Chair.
Got it. Senate Bill 93.
Senate Bill 93 is identical to House Bill 294 as passed by the House.
Move favorable.
Second.
Second.
All right. Madam Vice Chair,
Yes.
Delegate Brooks,
Aye.
Delegate Fisher,
Yeah. Aye.
Delegate Queen,
Yes.
Delegate Turner,
Yes.
Delegate Rogers,
Yes.
Delegate Carey,
Yes.
Delegate Jackson,
Yes.
Delegate Pippy,
Yes.
Delegate Mouts,
Yes.
Delegate Wilson,
Yep.
Delegate Impalaria,
Yes.
Delegate Branch,
Yep.
Delegate Valderrama,
Aye.
Delegate Walker,
Yes.
Delegate Chi,
Yes.
Delegate Adams,
Yes.
Delegate Arentz,
Yes.
Delegate Fennell,
Yes.
Delegate Charkoudian,
Yes.
Delegate Howard,
Yes.
Delegate Crosby,
Yes.
Delegate Watson.
Yes.
Motion carries. Senate Bill 205, please.
Senate Bill 205 is not identical to House Bill 12, Delegate Watson's bill on carryout and delivery of liquor. However, with the amendments in your packet, they will become identical to House Bill 12.
Move the amendment.
Second.
Second.
On this one, Bob, I want you, just so everybody knows what's going on, why we're doing it. Can you tell them what the Senate did and why I requested, I think it was me, they requested
Yeah.
to conform it to the House bill.
Exactly. The Senate made two major changes compared with what we passed out of the House. The first was that they would require local delivery to be approved by an ordinance or local law adopted by a local government. That is directly contrary to longstanding practice where the General Assembly has reserved alcohol regulation to itself and has not devolved it to the local, not even to the point of allowing a city council to have any say in where something is cited. So that's something that has raised a lot of hackles in the industries. The other thing that they did, which would probably be okay, actually would be to have the Department of Health do a study of the effects of delivery on health impacts. But whether you want to do health department or whether you'd want to do the alcohol and tobacco commission to do it, that's something maybe to save for conference if it gets that far.
All right. We haven't adopted the amendment yet, right?
Correct. That is correct.
Delegate Pippy and Delegate Watson, are you on the amendment or on the bill?
The amendments.
Amendment.
All right, then let's hold off on voting the amendment until after we've heard from the delegates. The first one I saw was Delegate Pippy, so forgive me if I got the order wrong.
It's fine.
All right, thank you, Mr. Chairman. I think the committee got a letter from MSLBA
Does this amendment, making it the same as the House version, satisfy all those concerns in that letter?
Yes.
Thank you.
Delegate Watson.
I just want to clarify something that Bob said. So what their amendment, what the Senate amendment does is it makes this an opt-in bill. So each jurisdiction would have to opt in to allow carry out and delivery alcohol for restaurants. But not only would they have to opt in, but they would use their county government to do it. So
Right.
they pass a law or an ordinance. What the industry would like to see is if we leave that language in there eventually through conference, that we make it a law, ordinance, or resolution, because in some counties resolutions have a shorter time period. But in general, that language is problematic. So the question is, how do we get around that, but still give the Senate what they want? And I guess we'll figure that out in conference.
Yeah, the other thing to note is that typically the state appointed boards, which are the boards of licensed commissioners, in most jurisdictions, those are a separate board. In some cases, they actually are the county council. That is the authority through which the state has regulated local alcohol licensing and operations, as opposed to having the county council acting as a county council or a board of county commissioners. So that's a pretty significant policy shift. More normally, you would have the board of licensed commissioners opting in if they chose to do that. And in some counties, for example, Howard, that would be actually the county council. But it's a major policy shift.
And that could be a compromise. I don't know, asking the board, if we have to, asking the board of license commissioners for each one to do it. But in any event, I don't want to get ahead of ourselves.
Yeah, I mean, to respond also to Delegate Pippi's question, the House version is what the both parties to that letter agreed in compromise. They would have each of them would have liked different dates, but they came to settle on 2023 as the sunset date for it, and to have the mechanism be the opt-out as opposed to the opt-in that we have. So they said nothing as far as the MDH study, as far as I'm aware. So this puts us into conference, essentially.
All right. All in favor signify by aye.
Aye.
Opposed, nay. Motion carry on the bill as amended.
Move the bill as amended.
Second.
Second.
Moved and seconded for favorable as amended for Senate Bill 205. Does anyone wish to be recorded in opposition?
Delegate
Delegate
Valderra.
Valderra is a no. Anyone else? Hearing none, seeing none. All others present voted aye. With one no, Delegate Impalaria.
Okay.
Let's go to 417, please.
Senate Bill 417 is identical to one of our House bills, 777.
Move favorable.
Second.
Moved and seconded for favorable on Senate Bill 417. Madam Vice Chair.
Yes.
Delegate Brooks.
Aye.
Delegate Fisher.
No.
Delegate Queen.
Yes.
Delegate Turner.
Yes.
Delegate Rogers.
Yes.
Delegate Carey.
Yes.
Delegate Jackson.
Yes.
Delegate Pippi.
No.
Delegate Mouts.
No.
Delegate Wilson.
Yep.
Delegate Impalaria.
No.
Delegate Branch.
Yep.
Delegate Valderrama.
Aye.
Delegate Walker.
Yep.
Delegate Chi.
Yes.
Delegate Adams.
No.
Delegate Arentz.
I don't see him on the call at the moment.
All right, let's excuse Delegate Arentz. Delegate Fennell.
Yes.
Delegate Charkoudian.
Yes.
Delegate Howard.
Yes. No.
I got you.
Thank you.
Delegate Crosby.
Yes.
and Delegate Watson.
Yes.
All right, motion carries, one excused. Senate Bill 503.
Senate Bill 503 is identical to House 345 as passed the House.
Move favorable.
Second.
Moved and seconded for favorable for Senate Bill 503. Madam Vice Chair,
Yes.
Delegate Brooks,
Yes.
Delegate Fisher,
Yes.
Delegate Queen,
Yes.
Delegate Turner,
Yes.
Delegate Rogers,
Yes.
Delegate Carey,
Yes.
Delegate Jackson,
Yes.
Delegate Pippy.
This is 503?
Yes,
Correct.
sir.
No.
Delegate Mouts,
No.
Delegate Wilson,
Yes.
Delegate Impalaria,
No.
Delegate Branch,
Yep.
Delegate Valderrama,
Aye.
Delegate Walker,
Yep.
Delegate Chi,
Yes.
Yes.
Delegate Adams.
Mr. Chair, could the council just briefly tell me what this bill does?
This is the Flower Branch. This is the natural gas upgrade of regulator bill from the Montgomery County explosion 4 years ago. That was Delegate Charcudian's bill in the House.
Okay. Yes.
Delegate Arentz is still excused. Delegate Fennell,
Yes.
Delegate Charcudian,
Yes.
Delegate Howard,
Yes.
Delegate Crosby,
Yes.
and Delegate Watson.
Yes.
Motion carries. Senate Bill 754 looks familiar.
It does, and it's a bill that was Delegate Brooks is over here. It had a very different fate than the last one. In point of fact, the committee killed the cross file of 754.
And what do we usually do with cross files?
We
If
normally
the cross file's dead, I'm not trying to, I just want to make sure we're consistent.
past practice would be to move unfavorable.
Kill the bill.
Unfavorable. Delegate Brooks, you want to make the motion?
No. Yeah. Move unfavorable. That's right.
Second.
All right, moved and seconded for an unfavorable. Just being consistent here, that's all we're doing.
Yes.
Madam Vice Chair,
Yes.
Delegate Brooks,
Yes.
Delegate Fisher,
Yes.
Delegate Queen,
Yes.
Delegate Turner,
Yes.
Delegate Rogers,
Yes.
Delegate Carey,
Yes.
Delegate Jackson,
Yes.
Delegate Pippy,
Yes to the unfavorable.
Delegate Mouts,
Yes.
Delegate Wilson,
Yes.
Delegate Impalaria,
Yes.
Delegate Branch,
Yep.
Delegate Valderrama,
Aye.
Delegate Walker,
Yes.
Delegate Chi,
Yes.
Delegate Adams,
Yes. Yes.
Delegate Arentz is excused unless he's made his way back.
No, he's out.
Delegate Fennell,
Yes.
Delegate Charcudian,
Yes.
Delegate Howard,
Yes.
Delegate Crosby,
Yes.
and Delegate Watson.
Yes.
Motion carries. Is there anything on that back page?
Yes.
There's one on the page 2.
821, Senate Bill
Senate
821.
Bill 821.
Senate Bill 821 is the cross file to Delegate Brooks's House 1232. This is the one that amends the manufacturer's licenses and offsite permits. What we did with his bill was to make the entire thing sunset in 2 years.
And you conformed the Senate?
We have an amendment to conform it to the House bill, yes.
Move the amendment.
Second.
All in favor signify by aye.
Aye.
Opposed, nay.
Move the
Motion
bill as
carried.
amended.
Second.
Moved and seconded for favorable on, what is it, Senate Bill?
821.
821. Yep.
All right, let me try this. Does anyone want to be recorded in opposition to the bill? Seeing none, hearing none, all present voted aye. Delegate Arentz is excused. So motion carries. All right, I put it off as long as I could. House Bill 581.
All right, Mr. Chair, is it all right if I pull up the reprint?
Yeah, that's a good idea, Laura. How do you want to proceed, just so we know what to expect? How do you want to go forward?
I was thinking I would walk through the reprint as it reflects the Business Regulation Subcommittee's work product, and then.
Were you going to
people
do
can
it
just-
section by section, or?
Yeah,
You know what? I'll just follow you. Let's
Okay.
let's try it that way.
We could have
Okay,
just
and if
voted
that-
it out, Mr. Chair. We could just.
Yeah, I'm sure that would have worked. So yeah, let's go through it section by section. Let's do this. If you have any questions, just sort of hold them or mark them down. I want council to get through it all, and then we can go back and we'll take the questions at that point.
I hope that you all received the reprint that I sent last night with the little cheat sheet about each section. I think that that's a helpful little guide since there's a lot in the bill. Business Regulation Subcommittee worked very hard on this.
I did not receive the reprint, Laura. Can you shoot that to me?
Yes.
Thank you.
Do you want me to send it right now?
Oh,
Please.
Either that or I can.
Either
That'll
one.
work.
To your,
Either one.
to your, what you call it, laptop?
Yeah. Yes, please.
Okay.
Thank
Thank
you,
you.
Madam
Thank you.
Vice.
Sure.
Okay. So this section of the bill that's struck would have required the establishment of a special enrollment period during an emergency. Some health insurers responded that the Maryland Health Benefit Exchange already has the authority to have a special enrollment period during an emergency, so that was removed. The next section of the bill would have enhanced the information that employers have to provide in a pay stub to include a statement of hazard pay, but you'll see later on in the reprint that the subcommittee recommended removing hazard pay from the bill. Now we're getting into the Maryland Essential Workers Protection Act itself. So there are a couple of definitions that dictate the scope. So the subcommittee recommended amending the definition of emergency so that an emergency would be limited to a catastrophic health emergency as defined under the public safety article that is the subject of an executive proclamation under the public safety article and is related to a communicable disease. Before, emergency had been broader to cover other executive orders or acts or declarations, as well as there was sort of a broader catch-all definition for emergency. So this is limited to a catastrophic health emergency that's the subject of an order by the governor, a proclamation by the governor. And it has to be related to a communicable disease, not any other type of health emergency. Essential employer is a person that employs an essential worker, and it includes a unit of state or local government. So governmental employers would be subject to the requirements in the bill. The subcommittee limited the scope of essential worker to be an individual who performs a duty or work responsibility during an emergency that cannot be performed remotely or is required to be completed at the work site. The underlined text on your screen is what the subcommittee added. So in order to be considered an essential worker, The individual has to provide services that the essential employer deems to be essential or critical to its operations. And the subcommittee recommended removing contractors and subcontractors from the definition of essential worker. Section 316.02 of the bill further limits the scope to say that the requirements in this subtitle only apply to employers that are in industries and sectors identified by the governor or a federal or state agency as needed or critical to remain in operation during the emergency. The bill as introduced had listed out specific sectors, and the subcommittee decided instead to leave it to the discretion of the governor or federal or state agencies to decide the scope in future emergencies. So we're going to be scrolling past the laundry list of industries that had been in the bill but is now not in the bill. This section of the bill that is struck would have required MEMA or a local emergency management agency to survey, to periodically evaluate and determine whether an emergency is occurring, and then to announce that an emergency is occurring. That the subcommittee felt that that extra step and agency involvement was not necessary because the scope of an emergency is limited to when the governor proclaims that there's a catastrophic health emergency. That was initially in the bill because emergency was not necessarily tied to an executive action, and now it is limited to an action by the governor. The next section of the bill, which the subcommittee has further refined, establishes some basic requirements for essential employers. So during what's considered an emergency, each essential employer is required to provide working conditions that comply with applicable safety standards that have been adopted by a federal and state agency. Subject to availability, provide necessary amounts of safety equipment recommended for usage during the emergency at no cost to essential workers. Adopt, maintain, and post written protocols to ensure an essential worker's access to information regarding the applicable standards that are in effect. And then there's one more on the next page. Provide or implement any other measures or requirements set by the governor or a federal or state agency to ensure the general health and safety of essential workers. This next section that is struck from the bill defined unsafe work environment and set up a separate right to refuse process so that a worker could make a complaint to the Commissioner of Labor and Industry and then refuse to perform a work responsibility. The subcommittee chose to instead bring in and cross-reference the existing right to refuse standard under the MOSH law. So we'll be getting to that in just a second. This next section that is struck would have required an individual employer to set up establish a health emergency preparedness plan. So that would have been an employer-specific plan with safety standards. So that has been removed from the bill. So this section here that's underlined 316.04, the new 316.04, is the cross-reference to the right to refuse standard under MOSH law. So there is a statute under Title V of the Labor and Employment article that sets out, the Department of Labor refers to it as the discrimination statute. That's the statute that lays out, basically says an employer may not discharge or discriminate against a worker for exercising certain rights. And then there's a regulation that's been adopted corollary to that, that lays out basically what a worker needs to prove in order to say that they have a right to refuse to perform a job responsibility. So this is cross-referencing that provision under the MOSH law. The new 316.05 lays out some disease mitigation requirements. So during an emergency, if an essential worker or any other worker has contracted the disease that is the subject of the emergency at the work site, the employer has to take proactive steps to minimize the risk of transmission, including informing essential workers that they may have been exposed. And then there's a requirement here that except as provided in paragraph 2, if an essential worker's health insurance coverage or other benefits do not cover the cost of testing for the communicable disease, during an emergency, the employer is required to pay for the testing for that disease. The exception being if an essential worker is able to obtain the testing free of charge. So really the employer is stepping in only if health insurance or some other benefits aren't covering it, or the worker does not have access to a free test. This next section of the bill requires an essential employer to report positive test results to the Department of Health. The Department of Health has to, when reporting the information, the employer has to include certain demographic information, but redact personal identifying information. And then MDH has to collect the results, categorize it by industry, and publish it in a format that's accessible to the public. And then the commissioner is required to adopt regulations as necessary to carry out that section. There was discussion in subcommittee yesterday about this point and the potential for it running up against HIPAA, and the Attorney General's office, I have no idea how they do what they do so quickly, but they have issued a letter in response, which I can share with the committee, that says that it is their view that it would not, that the requirement would not require an essential employer to violate HIPAA. So the Delegate Wilson spoke about this a little yesterday, but HIPAA specifically applies only to certain settings and organizations. And so the letter that we have says that this would not create a conflict with HIPAA. The next section here is the leave section of the bill. As introduced, there was a requirement that 3 days of paid bereavement leave and up to 14 days of health leave be provided. The subcommittee changed the language to more closely track what was in House Bill 1326. That's Delegate Dumais' bill about public health emergency leave. So it's been reclassified as public health emergency leave. It's important to note, and this is something different that I've not seen the committee do it before. The leave requirement only kicks in if there are federal or state funds for the leave. So what this bill is doing is it's setting up a framework for funds to be directed in an emergency, a health emergency. So it sort of sets up the reasons that the leave could be taken, the documentation requirements, which we'll get into in a bit, but the requirement is only in effect if the leave is, if the funding is affirmatively provided by, it would flow through the governor via budget amendment. The essential employer is required to provide the leave on the date the funding is made available. I cleaned this language up a little bit from subcommittee yesterday, so it's clear. It's just needs to be provided when the funding is made available to the employer. And then the leave is in addition to any other leave or benefit, including earned sick and safe leave. And then the bill specifies the different amounts that it would need to be provided. So the first category is if it's specified in a federal program or some other federal standard, it would need to be in that amount. And then if it's not specified under any sort of federal program or standard, it would need to be for a full-time worker, 112 hours, which is 14 days. And then there are different calculations for workers who work part-time or sort of less regularly. We're getting there. Thanks for hanging with me. I'm so tired of hearing my own voice this session. The next section here, subsection E, requires an essential employer to allow an essential worker to use the leave. Originally in House Bill 1326, the Vice Chair's bill, there were 9 reasons that a worker could take the leave. The subcommittee has limited it to 6. So to isolate without an order to do so because the essential worker has been diagnosed with the disease that is the subject of the emergency or is experiencing symptoms of the disease that is the subject of the emergency and the person's awaiting the test results. To seek or obtain a medical diagnosis, preventative care, or treatment because the person's been diagnosed. to care for a family member who is isolating without an order to do so because of the diagnosis of the disease, due to a determination by a health official or a healthcare professional that the worker's presence would jeopardize the health of other individuals, regardless of whether there's been a diagnosis. 5 is to care for a family member due to determination, same thing, by a health official or a healthcare professional that the presence would jeopardize the health of others, and that's regardless of whether there's been a diagnosis. And then the last reason is to care for a child or other family member when the care provider is unavailable or if the school is shut down, essentially. And then the next section is some construction provisions. These are similar to what exists under the Maryland Healthy Working Families Act. So an essential employer isn't required to compensate a worker for unused leave if the worker leaves employment. It doesn't preempt or otherwise affect any other more generous leave benefits available to the worker. It doesn't affect any workers' compensation benefits. It doesn't prohibit an employer from adopting a policy designed to curb abuse of the leave. And it may not be construed to prohibit an employer from providing additional leave. The next section here, I do see Delegate Charkoudian has her hand raised, Mr. Chair. Do you want?
I thought we were waiting until the end, Mr. Chair.
Yeah, let's get through it all and then we'll do the question.
Okay, I just didn't want to steamroll. Okay, so this is the last section of the leave requirement. So it's about documentation. So an employer may require documentation, and if a worker fails or refuses to provide it, the employer may refuse to pay for the leave. And the commissioner is required to adopt regulations regarding acceptable forms of documentation. This is the hazard pay and financial assistance with healthcare costs. The subcommittee recommended removing that from the bill. The new 31607 is the misclassification provision. The subcommittee changed the standard to knowing misclassification. So an essential employer is prohibited from knowingly misclassifying a worker as an independent contractor to avoid paying for any of the benefits due. And then this section here that's struck is the enforcement provisions. We will walk through what the subcommittee recommended instead. So the subcommittee heard from Commissioner Helminiak from the department about the existing enforcement authority that his unit or division has regarding employment safety and leave, enforcement of leave benefits. So rather than establishing a completely new enforcement scheme, the subcommittee endeavored to cross-reference the existing enforcement schemes where it made sense. So under the new 31608A, this is the right to refuse provision. So if an essential worker believes that the employer has violated that, the essential worker may seek enforcement of those rights. That's cross-referencing again the MOSH right to refuse statute. And the commissioner is required to respond in accordance with the existing enforcement provisions of the law. Under subsection B, if an essential worker believes that the employer has violated the leave provision of the bill, the worker is authorized to file a written complaint. And then the rest of what's laid out under subsection B has been brought over from the Maryland Healthy Working Families Act, the sick leave law. With the exception of the private right of action, there is no private right of action under this bill, but there is one under the sick leave law. And then in subsection C, if an essential worker believes the employer has violated any other provision, the essential worker is authorized to file a complaint with the commissioner, and the commissioner has to respond in accordance with the MOSH sort of general enforcement authority. And then we've amended, or you all would be amending section 5205, that's the MOSH statute, to give the commissioner, to actually require the commissioner to enforce the right to refuse statute and some of the other safety provisions of the bill. And then this is amending the actual most right to refuse statute to say that an employer or other person may not discharge or otherwise discriminate against an employee because the employee is an essential worker who exercises rights under this bill. Now we're getting to the uncodified sections. So we're in the home stretch. Section 2 is actually brought over. Delegate Valderra offered an amendment that brought over provisions that were somewhat changed from House Bill 124. You'll remember at the hearing that there's discussion about OSHA establishing an emergency temporary standard for COVID, which is just safety standards specific to and like best practices for employment settings during COVID. So what the uncodified language requires is that MOSH would need to immediately adopt a federal standard if one is adopted. If one is not adopted, MOSH would need to adopt a state emergency temporary standard. And that would be temporary and would expire at the conclusion of the health emergency or the adoption of a permanent aerosol transmissible standard by OSHA. And this is regardless of whether the federal standard is subject to federal litigation. And then the standard has to contain certain specifications and requirements, such as notification to the commissioner and the Department of Health within 24 hours of a positive case, notification to the commissioner within 24 hours if 3 or more workers tested positive, and then certain information would have to be posted on the at the work site. The next section requires the commissioner and the secretary to make available on the Department of Labor's website information related to COVID-19 in a manner that does not reveal personally identifiable information. I did want to point out while we were on this point, in case we don't circle back to it, it was brought to my attention that there's some potentially duplicative provisions in the bill regarding an employer's responsibility to report positive test cases. There's a permanent requirement in the bill that employers notify the Department of Health. This is when we were discussing the HIPAA, potential conflict with HIPAA. So employers here, this is permanent and ongoing for future emergencies. They would need to report to the Department of Health. The Department of Health would need to categorize the information and post it on its website. But in the uncodified language that is specific to the COVID-19 pandemic, the employers have to submit it also to the Department of Labor, and then the Department of Labor has to post that on its website. So it seemed that
oral motion. I'll be doing an oral motion on that to strike the codified language. I'm just waiting for you to get done.
Okay.
Because they're definitely in conflict. Conflicting.
All right. So
What section was that? I'm sorry, Laura. What section was that?
Sections 2 and 3. So I think what you could potentially do is just remove all of what's in section 3. So that basically MDH is just required to post the information. And then here where the employers would have to submit the information, you would strike references to the Commissioner of Labor and Industry. So it would just be MDH would be sort of the warehouse for the positive test information.
Okay.
And section 4 requires the Department of Health in consultation with the Department of Labor and local health departments to develop a template health emergency preparedness plan for responding to a catastrophic health emergency. The plan would need to be consistent with applicable standards, incorporate input from employers, and include the following provisions. 1 being the coordinated process for handling complaints related to unsafe working conditions during a catastrophic health emergency, and methods for raising public awareness about the process for making a complaint. And in addition to that report, on or before October 1st of this year, those same agencies would need to report to the General Assembly about recommendations for potential legislation to enhance their enforcement authority during a catastrophic health emergency. Section 5 requires most to report to the General Assembly on January 1st of next year regarding their enforcement actions on COVID-19, such as the number of complaints, site investigations, and any other information. And Section 6 requires the commissioner to adopt the regulations required in Section 2 and throughout the bill as soon as practicable. And Section 7 is the application provision of the bill. So this specifies that employers would not be made to or required to reimburse a worker for unpaid leave taken before the bill goes into effect, even if funding were made available at some later point by the government. And then the leave would need to be provided on the date that funding is made available to the employer. And then the last section, Section 8, is, we've removed the reference in the previous section that's struck through removes the reference to hazard pay and retroactivity. Hazard pay has been removed from the bill. And Section 8 is just that it's an emergency bill and that several of the provisions will sunset 6 months after the state of emergency ends. That's all I have, Mr. Chair.
And Mr. Chair, I don't know if you want me to make my oral motions, if you want to wait and take questions first. You're on mute, buddy.
You mute.
I said, let's go ahead and take the questions. We can get the motions in a little bit.
Okay.
I see two hands, three now. Delegate Pippi, Delegate Charkoudian, and then Delegate Ma.
Thank you, Mr. Chair. More power to the subcommittee that went through this bill. There's a lot of changes. I have one specific question on page 16. With the reprint, it says compensate an essential worker for unused public health emergency leave when the essential worker leaves employment. So can someone walk me through that? So someone didn't use their leave and then now the employer has to pay them for that leave they didn't use?
So this is a construction provision that says, let me find it.
It's just number one.
Yeah, it looks like the reprint didn't actually run correctly here. So it should say nothing in this section may be construed to, and then 1, 2, 3, 4. So these are nothing in this section may be construed to require an essential employer to compensate. So the bill may not be.
That's night and different what it actually says.
Yeah, it looks like the reprint did not run correctly, but that is what this section should say.
Okay, well,
and I'll make sure.
If it's fixed, then I'm good with that part. If it's not fixed, obviously that's a big difference, but okay, thank you.
That was never the intent of the subcommittee.
Got it.
Delegate Charkoudian.
Thank you, Mr. Chair. I also want to thank the subcommittee and the work group and everybody who put in, and staff who put in a ton of time into this bill. And I think there's a lot of really important pieces in here. I think that it may be in the uncodified language, but maybe if I could just share a concern that I have, and then if either staff or maybe Delegate Wilson or others can answer it. The broader concern that I have is about how poorly I think MOSH did this year. There were a number of requests at work sites for them to come and do an investigation about safety, sort of tied to this issue that was in Delegate Valderrama's bill about a temporary standard. And they essentially punted to local health departments and said it was sort of on them. So I know that folks reached out to me. I tried to get MOSH involved. We had a hearing at some point. MOSH indicated that they hadn't done any in person. In some cases they did, they had folks take the camera around, the employer take the camera around to show them that everything was just fine, which, is problematic when we're counting on them to, respond to a concern about workplace safety issues when somebody's raised that issue. So I think I see pieces of that in here, but I just want to make sure I'm tracking. So as this stands now, they have to are they coming up with they have to adopt a federal standard or an interim standard like right away? Is that right, for coronavirus? And then they have to come back with recommendations next year for a permanent plan for future pandemics, or what? Can you just, that's the part I think I'm not quite sure I'm tracking.
So, yes, so section 2 in the uncodified language requires MOSH to adopt a federal standard if there is one. And if there is not a federal standard, then MOSH has to adopt a state emergency temporary standard,
So that would be,
specific to COVID.
that's like
just-
what Virginia, I'm sorry.
I'm sorry.
Is that's like what Virginia did?
Yes. So,
Specific to
but
COVID.
sort of looking forward from moving past the COVID-19 pandemic, this section 4 of the bill requires the Department of Health, in consultation with labor and local health departments, to develop this template plan for responding to catastrophic health emergencies. And as part of that, they would need to include a coordinated process for handling complaints and methods for raising awareness about that. And then there's a separate report requirement for October 1st of this year. So the same agencies would need to report on recommendations for potential legislation to enhance the agency's enforcement authority.
So I guess maybe Mr. Chair or Vice or Delegate Wilson, Subcommittee Chair, is it your sense that that's kind of still unfinished? It's my sense it's unfinished. That's how I read this. I'm hoping that this means we would come back and set ourselves up for, God forbid, a future pandemic to have MOSH be in a position to actually do some enforcement, unlike what they did over the last year.
That's precisely why we brought the health department in, number one, because they have immediate ability to immediately enforce something. They don't have to use a court system. They're the ones who are going to be coordinating what needs to be done as far as taking on the complaints and how to perform the investigation. In addition, we had them report to us. So if there are things we're missing, instead of trying to tell them their job, which we may not in fact know all the ramifications of what they can do, we're allowing them to create a report for us to find out what else and other powers they may need from us. So if we have to come back, we can. But they're going to adopt our, like you said, like they're going to adopt any federal regulations or guidelines that are promulgated. And then they're going to be the ones, folks, so we're taking it off of MOSH and putting it in Department of Health. So I guess I'm not really sure what your question is, because it's, I mean, the way she laid it out is that by October 1st, they're supposed to have a plan together for us to see on how they're to handle this one and any other issues that come about for emergency or catastrophic health emergency.
August 1 for the coordinated response. The October 1 is the report on statutory changes.
There you go. Apologize. August 1.
Yeah, I think kind of what happened this year, at least it seems to me, is that MOSH, which is the body that's supposed to be doing workplace safety, did not enforce workplace safety standards under the general provision and didn't adopt emergency provisions. So essentially nobody was enforcing workplace safety in and of itself. So you had health departments enforcing it from the perspective of like workplaces that were open to the public. And so you had health departments kind of ensuring that the general public engaging with those restaurants or grocery stores, like that's where you had the health department enforcement. But you sort of like, there were places that were like, you know, pallet recycling manufacturing facilities that nobody was enforcing, neither the health department nor MOSH was enforcing standards. And so I just want to make sure that in assigning this to both of them together, we don't set ourselves up.
It's not together. It's for we're letting the health department be the main one, because that was my point. Is I know when they can always go in there where there's food. That's never a problem for health, and we wanted to done at a state level, not where local people do their own thing. The local health departments. It's going to be started and performed at a state level. One and two. That's what we're asking them, to make sure that we give them whatever authority they need to go into, like you said, a pellet making or a furniture store, or someplace that doesn't sell food that normally they would not have purview over, but for the fact that this is considered a health, a catastrophe. So we want to make sure that's why we put them as a central repository for this information. And
The
we're,
only thing that I wanted to add, if I could, is the subcommittee, as I mentioned, Commissioner Helminiak came, and the way that he sort of explained it is that the governor issued an executive order that gave, sorry, they're testing the floor system. I'll have to turn that off. The governor issued an executive order that gave local health departments special additional enforcement authority during COVID. And so the local health departments had the ability to go in and shut down places of employment, whereas it sounded like the Department of Labor itself did not, as they presented it, there was not the authority to take some of those immediate actions. So the subcommittee discussed, wanting to get more information, get this plan out, and then have a recommendation from the agencies themselves about what additional enforcement authority they needed.
because we got caught around the axle trying to find out what we should tell them to do. And it seems like it's better to have the subject matter experts explain us what they still need to be able to do their job under the guidelines we have laid out of what we expect from them. Otherwise, we're just all over the board guessing. Because, go ahead.
Okay. Maybe we get another bite at the apple next session for preparing for the future. I guess my concern is that what essentially happened is that we had Virginia as a model where a governor said there's a public health emergency and VOSH, whatever it is there, you're going to adopt standards for workplace safety. And in Maryland, many of us said to the governor and to motion to DOL, we think you should do what Virginia did. And they said, we don't need to do what Virginia did because we have the general standard. I can't think of exactly what it's called. So we don't need to do that. And we said, well, if you have that standard and that lets you address workplace safety, health and safety issues, if you don't need what Virginia did, then could you go and see what's going on in these places where we have employees contacting us and saying, it's unsafe, and I've called the complaint in, and Moshe had the boss take the camera around and show that people were wearing masks. That's not an acceptable investigation, right? So I guess like in some ways, I feel like we know what is needed, but we need to tell them. They've chosen not to, the commissioner said to us, well, we're just educating employers. That's not acceptable. We need somebody doing investigations, right?
Well, number one, they have 2 weeks after the effective date of this act, they have to do just that and adopt that emergency standard.
What Virginia has.
Correct.
Yes.
Okay. So that's
within
now.
2 weeks. That's regardless of all the other things we're talking about. That has to happen.
So that's for now. That's good. Thank you.
And then in addition, we're building up for the, again, after the pandemic or the furtherance of this pandemic.
So it is your sense that we can come back next session and establish something so that in, God forbid, a future pandemic, they can't punt or point or say we don't have the authority.
Without a doubt. And that's one of the things I wanted to avoid is when they kick it down to the locals. That's just what Trump did to us, where he said, oh, each state do their own thing.
That's exactly right.
Good way, because we don't all get the same outcome. I want to ensure that the entire state has the same outcome, which is why we're focusing on the health department, the state health department, not to kick it down to the locals. But we also didn't want to get so wrapped up that we were telling them what to do when we don't even know their full abilities, which is why we're requiring the reports to come back to us.
Okay. I guess my concern is that part of what happened is the health department was so overwhelmed with testing and prepping for vaccines and so on that the agency that we have that's supposed to do workplace safety was pointing to the health department, but the health department didn't have the capacity to do it even if they had wanted to.
And that will be part of the report and part of the report back to us of what they need to do their job.
I appreciate that. I'll keep an eye on this process and we'll work on,
I know you will. Thank you.
Thank you.
Delegate Pippi and Mouts, I don't know if your hands are still up from previous or these new questions.
Chairman, mine's still up.
Okay, Delegate Mouts.
Yeah, thank you. And I just, in understanding the bill, and this is for Laura, I'm trying to, so the bill takes effect.
It's an emergency bill.
Emergency bill.
No, but what's the trigger for these provisions to become law? I mean,
it's an emergency bill, so the it would take effect upon the governor's signature or the override of a veto. But the
He
leave-
may be, if I can, Delegate Mouser, I think, Laura, it's the
leave.
about the declaration.
Declaration.
By the governor or whomever. Yeah, I think you all settled on the governor making a state of emergency, public health emergency. That's
correct.
That's the trigger.
Correct.
Okay. Yeah, so the governor would declare a state of emergency, and it would have to be a health emergency related to a communicable disease. So we're in that right now, correct?
Right.
Yep.
This bill passes and it becomes law immediately, correct?
Right. That's why I was saying that it is, that's why I was responding to your question in the way that I was, because we are, unless things change before this, becomes effective, it would be effective immediately. With the exception of the leave provision. The leave provision would only kick in if the governor specifically, I believe by budget amendment, had state funds dedicated to pay employers so that they could provide the leave.
Yeah, but it didn't, so the governor, our governor, Governor Hogan, he's enumerated a number of essential businesses in his executive orders. So those would fall into the categories established by the bill, correct?
Yes. Yes.
Yep.
And then when the operative paragraphs or the operative lines of this bill would no longer take effect, when would it? So when the governor would have to rescind the order, the emergency order, or when does this end?
Just when the state of emergency ends. So as I understand it, with these executive actions, they're for a limited duration, I think like 30 days or something. And so Governor Hogan has been renewing the executive orders and the executive proclamation. So at some point it would not be renewed and then it would lapse.
Okay, so as soon as the executive order terminates, then the operative paragraphs or lines terminate also.
Mm-hmm.
Thank you.
They don't terminate, but they just wouldn't be in effect.
Yeah, okay, exactly. Yeah. Thank you. That was it, Chairman.
No problem. Is anyone else? I don't want to miss anybody, and with the screen up, I could. So if you want,
I can stop sharing screen.
I would like to make an oral motion, but I do have one question to ask Laura first. Laura, on 3-1606 D 2B, basically when we're talking about how to divvy up the pay, as we said before, I'm going to need some examples for that because that's still going to be mathematically very difficult. But the one thing I just wanted to ask on B, go up to the top right there where it says for part-time. I agreed. Did we talked about taking out the 2 week and just putting a 4 week period?
Okay.
Yeah, we did.
Okay, I can remove that.
I would just want to make an oral motion if we could strike the 2 week or.
Okay, I apologize.
No, please. We threw a whole lot at you. You kept track of almost all of it, so you're fine. And I'd also like to make an oral motion, Mr. Chair, to basically strike out all section 3, and then in section 2, I believe, strike out any references to the Commissioner of Labor. I think that's the correct way of doing it, Laura.
So in
The
regard to notice by the employer, if you could remove the commissioner, so the employer would be, let me just scroll down to it. So each employer, so the emergency temporary standard that's adopted, currently it says shall require each employer to notify the Commissioner of Labor and Industry and MDH. So I think you're proposing to remove the Commissioner of Labor and Industry. So it would be just the plan, the standard would need to require employers to submit it just to MDH.
Correct.
And then to notify MDH instead of the Commissioner of Labor and Industry of positive test
Correct.
results. And then you had suggested removing entirely what's in the uncodified section 3 here.
Yes.
Does someone need to move the amendment?
I'll move the amendments, including the one about 2 weeks to just 4 weeks.
Second.
Thank you.
Delegate Adams.
Thank you, Mr. Chair. Laura, you're actually where I wanted to kind of maybe try to strike a friendly amendment, and I'll be brief. Section 4B2, where it says incorporate input from employers. Where I was headed with that for the committee was we got some feedback from larger entities. I'm thinking of maybe construction projects or food processors, manufacturers, where there may be an appetite to try to get a pre-inspection and or some agency that would regulate or oversee their operations to, go through the facility and do a, I call it a pre-inspection because what I think a manufacturer would want to try to avoid if they're essential, if we deem them essential, they need to operate, avoid the potential of having workers just carte blanche walking off the floor. And so part of what I brought up yesterday was incorporated here, which is there's a health emergency preparedness plan where we're going to incorporate input for the employers. But I asked if the committee would be okay with including following provisions and maybe have one of those be, adopt federal inspection standards that would relate to the conditions of the environment that they're working in. So I don't know how to word that in a legal frame of reference. That's where I was headed with that. And I'd like to be clear enough in uncodified language. If we're going to go through this preparedness plan, I think it would be good to have guidance where the employers can speak to facilitating that sort of process.
So Delegate Adams, what's in B1 isn't speaking to what you're talking about, that the plan has to be consistent with applicable federal and state standards.
Point that to me on the screen.
And so you were talking about section 4B2, I think.
Yes.
B1 requires that the plan be consistent with any basically existing applicable standards.
So you think it's possible for, say, like a food processor, there's a federal standard, and if the federal standard is to do a pre-inspection of the facilities that, perhaps the employers can incorporate input into this plan that maybe directly to that process, so they can that their plan is to do these sort of inspections that, yeah.
Sure. Well, I guess sure. What, the way I understand section 4, it's the agencies getting this plan together from a high level. So not necessarily, I guess it could be granular, industry specific, but I think that Delegate Wilson and the Vice Chair were envisioning it more as kind of a roadmap for a future catastrophic health emergency and how complaints should be routed, because there's all these different agencies involved. Mm-hmm. And so I guess that was kind of how I was understanding this. How would you propose to change the incorporate input from employers to?
No, I think getting the input from employers to speak to the federal and state standards, and you're saying the plan is a global plan, but I think that's the right place to put something like that, because if we have essential employers, and I'm using food as an example because what's more essential than housing and food, but that we find some ways to help these facilities meet the obligations of the bill, but also do it in a way that helps them expedite the. Laura, I'm fine with this the way it is. I mean, I'm not getting any guidance from anybody else other than my own sense that I think it's important.
Well, I mean, Delegate Adams, I do think that it's the sort of, particularly since you've spoken to some of these, or at least you've got, when they see this bill, it's the kind of thing that I think you can tell what you need to tell the group that's putting together the emergency preparedness plan is about what you want from the inspection perspective.
Okay.
And done through the federal level as well, because again, they're still going to be, we're adopting, we have to do what's consistent with the federal guidance. I think, Mr. Chair, are we voting this out today?
That's the plan.
Outstanding. I know the bells are ringing, so I know you got some work.
All right, so I moved and the amendments were seconded, that the oral amendments. I don't remember, did we vote them?
They haven't been
We have
adopted.
not. Delegate, let me go to Delegate Howard.
So just
Sorry.
Laura, very quick. That's okay. So just very quickly. I know we got things to do. Even though federal funds are in place, passed down to the state, testing is given out for free in the state now, largely. The leave portion of this bill, just to be clear for all the members, the leave portion of this bill, although those mechanisms that are outlined in that bill are in place, but those mechanisms, although they're outlined in place for now, the leave portion of this bill is solely prospective.
Right, so the governor would have to take an affirmative step.
Right.
Okay, thank you.
All right. On the amendment, all in favor signify by aye.
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 Opposed, nay.
Aye.
Motion carries.
So then I would move the rest of the committee amendments that Laura just went through.
Second.
Second.
All in favor signify by aye.
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 Opposed, nay.
Now I have moved the bill favorable as amended.
Second.
Any discussion? If not, Madam Vice Chair,
Yes.
Delegate Brooks,
Aye.
Delegate Fisher,
No way.
Delegate Queen,
Yes.
Delegate Turner,
Yes.
Delegate Rogers,
Yes.
Delegate Carey,
Yes.
Delegate Jackson,
Yes.
Delegate Pippy,
No.
Delegate Mount,
No.
Delegate Wilson,
Yes.
Delegate Impalaria. Is Delegate Impalaria with us? Not, Delegate Impalaria is excused. Delegate Branch,
Yeah.
Delegate Valderrama,
Aye.
Delegate Walker,
Yes, sir.
Delegate Chi,
Yes.
Delegate Adams,
No.
Delegate Arentz is excused. Delegate Fennell,
Yes.
Delegate Charkoudian,
Yes.
Delegate Howard,
No.
Delegate Crosby,
Yes.
Delegate Watson.
Yes.
Motion carries. Thank you all very
Wait,
much.
Mr. Chair,
Laura,
we have 5 concurrences. Can we quickly blow through those?
quickly.
Okay. So the first concurrence is for House Bill 37. That's Delegate Valderrama's prevailing wage bill. The Senate amendments exempt legislative bond initiatives, so it conforms it to Senate Bill 35, which you all already passed.
Is there a motion to concur?
Motion to concur.
Okay,
All in
thank-
favor signify by aye.
Aye.
Opposed, nay. Motion carries.
House Bill 261 is Senator Klossmeyer's cross-file of Delegate Branch's battery charged fence bill. The Senate amendments remove the exemption from deer fencing and livestock fencing that Delegate Szeliga offered on the House floor. So that's a policy decision for you all, whether you want to get in a little back and forth with them about that fencing or not.
What did we,
What
I
did they
thought
do
that
to
came
fence?
up. We said no, or did we say yes to it on the House floor?
It
We
was
said yes,
accepted.
Mr. Chair.
It was
Okay.
accepted as being sort of clarifying.
Because the
Okay.
it wasn't intent to have the farmers who put this stuff around their fields.
Got it. Yep. All in favor signify
Well,
by aye.
Wait,
so you're
wait,
moving not
aye.
to concur?
They're moving not, to- what are we moving to do, Mr.
Oh,
Chair?
we're moving not to concur?
Yeah, because
So-
they took it out.
Unless, yeah.
You have to decide. They struck that from the bill. You have to
Oh,
decide.
okay. All right, definitely. Is there a motion not to concur?
Motion to not concur, Mr. Chair.
Second.
Do you want
All
to
in
appoint
favor?
conferees? Oh,
Yeah, if they do it, send somebody from, send two people that
I'll
we're
go.
mad with CT.
maybe Delegate Branch, since he's the sponsor.
Okay.
Okay, Wilson, Branch, and we need one more, but I can follow up with you about it. Okay. All right, the next one is House Bill 908.
Send, you know what? No, don't follow up with me about it. Send Kris with him.
There you go.
Adams?
Delegate Adams.
Yep, I was
Okay.
gonna say that anyway.
Okay. House Bill 908 is the next, that is the cross-file of Delegate Carey's bill, UI bill about payment plans. The Senate amendments, it adds the larger reimbursers that they may elect to defer payments for Q3 of this year. So that's consistent with the form that you passed out the Senate bill.
So that's a motion to concur.
Motion to concur.
Second.
Second.
All in favor signify by aye.
Aye.
Opposed, nay.
The next one is,
Hold on. Seth, are you trying to get in or is your hand just left up from previous?
Of course it is.
Okay, go on, Laura.
there's only two more. House Bill 1002 is Delegate Charkoudian's UI bill. The Senate amendments established that data sharing requirement that was in Senate Bill 893 that you all passed already, and there were a number of other changes to conform her bill to 893.
Move to conform, or move to concur.
Second.
Second.
All in favor signify by aye.
Aye.
Opposed, nay. Motion carries. Last one.
Last one is House Bill 1138. That's Delegate Carey's UI bill about the disaster report requirements. The Senate amendments changed the on and off triggers for a disaster determination and streamline the reporting requirement. This is consistent with the form that you passed the Senate bill.
Motion to
Move to
concur.
concur.
Second.
All in favor signify by aye.
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 Opposed, nay. Motion carries. Thanks, everybody. Laura, thanks again. I mean, thanks to the
Yes,
subcommittee.
thanks,
That was a
Laura.
lot of work,
Thank you,
but
Laura.
Definitely, I know,
Thank you.
Laura, you put in a lot of hours on this, so we definitely appreciate it. Last one to the
You're welcome.
floor is something. So I will see you guys.